Hello everyone, I'm Steve Savant, syndicated financial columnist and money color commentator. On today's show, estate planning for executives and business owners. Part 3 in our series on financial security through tax advantage strategies with nationally recognized retirement authority, Charlie Day. Welcome to the third segment, Charlie.
Thank you, Steve. This is fun.
Charlie, we are in actuarial heaven here, right? I mean, we're talking about major league deductions. Most executives are looking for perks, way different than the conventional perks of a 162 or a 401k. They're looking for extra benefits. But the owner, especially entrepreneurs that own their own business, family business, they're looking for major deductions and way to not only park money aside and get the deduction, but have these ancillary benefits that you're bringing up that most people never bring up. So let's go ahead. Now we're talking about, you promised us in the last one that this is not, that death benefit is not going to land in my estate. So,
yes.
So let's keep on that theme and then we'll
Well,
go to
you see, the problem with a traditional defined contribution or defined benefit, or what I call lump sum focused plans, is that the values are included in the estate, and it is the most expensive asset in one's estate. To get liquidity, you have to pay income tax, and if it's included in your estate, you pay estate tax, and if that's the only source of money you have, you're going to be paying income tax on the money that you have to pay for estate taxes. In '94, we formed our firm, and we established the benefit focus regimen platform. Working with my estate planning and ERISA attorneys, we saw a fundamental way to bypass the estate tax structure. First, the nature of the benefit is a benefit stream that continues for as long as you live, and then it ends. The asset that's providing that benefit is held inside that plan and trust, and it stays there and is not attributed to anybody. We call that an actuarial gain to the plan. And we'll talk about that in the dynasty trust aspects. But for the moment, let's finish up with the death benefit provision, because the death benefit provision is the way you're able to bring money out of the plan on an income tax favored basis. And if the spouse has used her qualified disclaimer, then the non-participant trustee in the plan has the following rules to follow. And that takes us to this slide. As long as the participant has no right to the plan assets, which is characteristic of a benefit-based plan, does not name the beneficiary, our plan document provides for a hierarchy definition of beneficiaries. First, the spouse, subject to a qualified disclaimer. Second, the trust of the participant. So if the spouse disclaims it, the non-participant trustee can go to the trustee and say, will you like to have this? And the trustee says, sure, and receives the money. And that death benefit moves potentially outside the estate. There are other provisions to wall off incidents of ownership. The participant can't buy the policy, can't borrow it. And it is all in the power of the non-participant trustee that we are able to effectively create this transaction.
Now, without this, you do not have the segregation power to keep that out of their estate.
Right.
So these are some of the things. Now, just to bring comfort to people who are listening to say, sounds really great, Charlie, but am I losing control here? Or am I okay with losing control?
Well, you're okay in losing control because you have total control. First of all, you're the plan sponsor, so you have the power of the pen. You can amend this thing, okay? You're the trustee, so you make the decisions as how the money is invested. And third, you're the plan participant, so all your rights can be enforced under the power of ERISA. So you're 1 in 3 persons. I mean, this is kind of like the pension trinity. So, you have total power. You don't need to own it because you control it. And that is the heart.
So I just heard you say a very distinctive difference. Controlling is different than owning.
Owning.
Yeah. And that distinction is very big in the way you explain this.
Yeah, and it is a structure that cannot exist by definition in a lump sum based plan.
Okay, now we're into estate planning here. Let's talk about some of the benefits again.
Okay. Well, we know that as a participant, you don't have a right to the assets. And as a result, when you die, there are no assets in your estate for federal estate tax purposes. Now, we've already discussed that the death benefit may be outside the estate if the spouse exercises her qualified disclaimer. And here we suggest that you discuss this matter in more detail with an estate planning attorney where we can help facilitate that discussion.
There would be no reason for her not to sign that waiver. Is that correct?
Well, she's going to receive this income stream for the rest of her life. And if the death benefit goes to the trust where the children, she could be an income beneficiary that could support supplemental income for health maintenance and support. What's called the 5x5 powers.
So there'd be really no economic reason to bring it back into the estate and hurt us to take constructive receipt of the death benefit.
Correct.
To my knowledge, if I'm hearing correctly.
Yeah, right.
All right. Well, let's close off by walking through. Give me the summary again. We have to, the entity.
We need to have an entity that has business purpose. You have to have compensation, a W-2 compensation, because that's the only form of compensation that can be benefited. And it needs to meet a reasonableness of test. For example, I have clients who want to add their spouse to double up the deduction. Well, I had a case where the guy was 52. His wife was the office manager for the last 20 years, and he was paying her $30,000. And in our meeting with the CPA, who happened to be a classmate of hers, she was also a CPA, I turned to the accountant and I said, what would you have to pay this person, pay a person to do what Ima does? And he says, $100,000. And I said, well, Ima, you're only getting 30. If we could make up for the years you haven't received reasonable compensation, let's take her up to $250,000. Well, Ima became a very good friend. The client's accountant said, yeah, we can support that. It's reasonable. And as a result, we were able to double the potential deduction for this family. It went from like $600,000 for him and another $550,000 for her, over $1 million.
Quick question. Are they both separate plans then?
No, all in one plan.
Still in one plan.
Right.
Okay.
But you see, what we've done then is created a retirement income for both of them that both cannot outlive of over $400,000.
So this step, you've really simplified this. This is not as deep as I thought when I first saw your presentation on the big slide deck. So once
we have an entity that has business purpose. The pension plan has, if it's benefit-based, has these special provisions where you have the two trustees and you have this hierarchy of beneficiary designations so that the death benefit moves out, and a restriction that the participant can't buy, name the beneficiary, can't buy the policy or borrow from it. And then having a trust for the participant ready to receive the proceeds if the spouse disclaims it.
I love the distinction in this segment between I didn't really lose control. I may not be the owner, but I didn't lose control.
You have total control.
Unbelievable.
You don't.
Well, don't forget to watch our next segment on business succession planning for executives and business owners, part 4 in our series on financial security through tax advantage strategies. And keep in mind, before moving forward with any of the ideas on our show, always check with your tax consultant, legal counsel, or your financial advisor. You've been watching Steve Savant's Money, the game of the game.